Good morning, ladies and gentlemen. Welcome to Bexar County Court at Law Number 6 and the Bexar County Veterans Treatment Court. Today is Friday, the 15th of October, 2021. It is approximately 10:15 a.m. And we have 4 cases set for pretrial motions. The primary premise being motion to dismiss for lack of speedy trial. The first case I have is called 641136, style State of Texas versus Ricardo Galindo, represented by Mr. Andrew Del Cueto. The next case I have is called 61134, State of Texas versus Scott Moorman, represented by Mr. Ernie Acevedo.
Your Honor, just for your information, Mr. Acevedo is going to be signing in a few minutes.
Okay. Cause number 568917, versus Lydia Martinez, represented by Mr. Ron Zimmerman, and 619339, State of Texas versus Tyler Howard, represented by Mr. Ross Brendel. Representing the state in all matters will be Mr. Guillermo Flores and Ms. Megan Galloway. And let's start with Mr. Del Cueto in cause number 641136. I have a pretrial motion filed, style defendant's motion to dismiss for want of speedy trial. Would you please advise the court and the state what exactly your premise is and what you're requesting?
We're requesting at this time a dismissal for want of speedy trial, Judge.
Okay. At this point in time, let's get all the dates on the table so everybody's on the same sheet of music. What is the date of the arrest on this case?
6/13 of 2020. Judge, if you'll allow me to share the screen I've organized.
Yeah, sure.
Things. Okay. Pat, will you allow me to share the screen, please?
Pat, your mic's turned off.
Yes. Does that help you at all? Because
Can I share my screen?
I don't know how you do that. It's up there. Participants I can do mine, but I don't know how you do yours. Hold on, let me check. See if there's a way to do that. Share to breakout room sound. I don't know that I can't.
There's
Pat,
a way to do it. I just don't know how to do it.
Pat, can you hear me?
Yes.
I think you have to give him hosting capabilities.
Oh, I have to put him as a host. That would be the deal. Okay, hold on. Let me stop this first. Let me see if I can give you hosting. I have to find you here. I make you a co-host. Yes, now you should be able to see it. Yes?
Awesome. Thank you,
Okay.
Pat, very much.
No, thank you, Megan.
Judge, can you see this portion of the screen?
I see lots of color like a flag. I don't see
Okay.
a document.
I'm gonna put stuff up, Judge.
Okay.
Okay. This, and I would like to label this as Defense Exhibit 1.
Okay.
This was our original filing, Judge.
Okay.
And you'll see in the body, we say we want a speedy trial. We don't ask for dismissal. We ask for a speedy trial. Okay. Then, if you'll notice, this is the Bexar County website, and I'd like to introduce, the first one was Defense Exhibit 1. This would be Defense Exhibit 2. And eventually I'm
State
going to
any
add,
objection? Hang on just a second, Andrew. State any objection for introduction of these two documents for purposes of this hearing only?
No objection, Your Honor.
Defense Exhibit 1 and 2 for identification are admitted as Defense Exhibit 1 and 2. Go ahead, Andrew.
and if you'll note, Judge, on this particular day, this is the offense date. I'm the attorney. And the only thing that's incorrect, Judge, because I want to be very upfront with the court, is This, of course, is not correct.
Okay, which specific entry is not correct?
Where the first entry, where it says 6/15/2001,
Right,
that is incorrect,
okay.
okay? So I don't want that to be part or to muddy up the hearing, right?
Okay.
Okay, so we have the date of 6/11/2020 was the inception of this case. Then on 6/15/2020 is when I filed the speedy trial, which is literally 4 days after the arrest. And I won't go into speedy trial arguments right now. You wanted to go through a time frame, and I wanted to go through a time frame.
Okay.
Then on 8/16/2021, the case was set for trial, and it's going to be set for 10/25/2021. But other than that, there's been no activity on the case.
What date was the information filed by the state?
It was filed on that day, Judge, or close to that day, 6/11/2020.
6/15?
No, 6/12. Remember, Judge, this one is not any good. I don't know why it's here. But on 6/11/2020, the information was filed.
All right. That seems impossible. They can't file the information on the same date of the offense. Is that more or less true?
Well, it shows, I can't really tell, but you're assigned on the same day as a court, 6/11/2020. And the complaint says
would have
it's
been
been
filed. Go ahead, I'm sorry.
The complaint says it was filed, Judge, on 6/11/2020, according to the Bexar County records.
And that's normal. When is the information filed? State, can you throw in here, do you have information on the exact date that the information was filed by the state?
Your Honor, we would ask that you take judicial notice of the D page. And so on June 11/2020, that is when the defendant was arrested in this case, booked in the Bexar County Jail, and released on bond from the Bexar County Jail. The complaint was received by central filing on June 23/2020. So that is when the charging documents were formally filed.
So the charging document, and I'll mark it here, and if I'm incorrect, please correct me, State.
It's
This
the one,
date.
it's the one, that's correct. It's the one directly under that where it says complaint received CF. That means that the
Okay.
complaint was received
All
by
right.
central.
Is that the date the information was filed? Obviously, the complaint and the information normally are filed together, are they not?
That's correct, Your Honor.
All right. Andrew, do you agree that the information and the complaint were filed on 6/23/20?
Yes, Judge.
All right, so we're good to go on that.
And
And go ahead.
may I continue, Judge?
You bet. I can't hear anybody. Is anything going on?
I'm putting stuff up, Judge.
Okay, no problem.
Then if you'll note, Judge, that we file our motion to dismiss for one of speedy trial.
On August 12th, 21, correct?
Yes, on August 12th, 21. And again, I'm not going into any, and there's a long litany of case law and arguments that we make in our particular motion.
And let me interject at this point. Do we all agree that the COVID problem originated plus or minus March of 2020? Does that sound right?
That's fine with me, Judge.
All right. State, is that okay with you?
Yes, Your Honor.
Okay, go ahead, Andrew.
And Judge, so that is defense exhibit number 3. I would like to introduce that as well, if that's okay with you.
Notice requesting additional discovery. That's what you want to be Defense Exhibit 3?
No, I'm sorry. The motion to dismiss for one of speedy trial.
Okay. So state any objection to what has been marked as Defense Exhibit 3 for identification, which is defendant's motion to dismiss for want of speedy trial, which was filed on, it looks like 8/12/21.
No objection, Your Honor.
It shall be admitted for purposes of this hearing only. Go ahead, Andrew.
And just, it's part of my argument, Judge, and since I have all the documentation organized, if I could just proceed with the documentation and then I'll relate to the documentation throughout the arguments.
Okay.
Judge, if you'll note, on the same day that we filed our request for a speedy trial, we also filed our request for additional discovery. I mean, we also filed our request for discovery under 3914. We filed a request the same day. So that was on 6/15 of 2020. But as of December of 2020, almost basically January of 2021, we were still missing these things. And in fact, today, we're still missing the MDTs and the handwritten notes of Officer Trevino.
What's an MDT? Mike Delta Tango, what is that?
It is a mobile data terminal. So this is, and just, if you don't know, Judge, think of it as an inter-agency email system that SAPD officers can communicate with each other on this system. Because in this particular case, I'm not trying to get into the facts at all about the case, but 3 officers were there at the scene.
And let me interject at this time, are MDTs and copies of handwritten notes by the arresting officer normally discoverable in San
Yes,
Antonio, Bexar
Judge.
County, Texas? Is that correct?
Yes, Judge.
Get 'em
Yes.
on every case. All right, State, do you agree with that? Ms. Galloway, your microphone's
I
off.
apologize, Your Honor. I would agree that they are discoverable. However, those documents are not traditionally turned in by the arresting agency to our office, so they are not in our possession. Additional investigation would have to be conducted to obtain that evidence, Your Honor.
Okay, did the Bexar County Criminal District Attorney's Office specifically request those 2 areas of items for the defense upon defense request for discovery? And this is before your time. It would have been somebody else way back when.
That would be correct, Your Honor. And I do not believe that information was requested at
And
that
right
time.
now, as we speak, is the state aware of the availability of MDTs and any handwritten notes by the arresting officer on this specific case?
Your Honor, that evidence is not in our possession, and I am unaware if it is available. However, I will request that information from SAPD.
Okay, go ahead, Mr. Duqueto. You made your point on that one.
Okay, Judge. I'm sorry. Can I introduce this as defense exhibit number 4, Judge?
Notice requesting additional discovery is what you want to be admitted as defense exhibit 4 for identification?
Yes, Judge.
All right, any objection from the state?
No objection, Your Honor.
Defense exhibit 4 for identification is now admitted into evidence as defense exhibit 4 for purposes of this hearing only. Go ahead, Mr. Duqueto.
Okay, Judge. So we are under a particular law, and you mentioned COVID, right? We're under particular orders by the Supreme Court, right? So this is the particular order that we're under. I would like this to be defense exhibit number 5.
Any objection, state? Megan, your microphone's turned off.
No objection, Your Honor.
No objection from the state. Defense Exhibit 5 for identification is admitted into evidence as Defense Exhibit 5 for purposes of this hearing only. Go ahead.
And I would like to turn the court's attention to defendant's exhibit number 5 on paragraph 3.
Reading into the record, paragraph 3 says, subject only to constitutional limitations, all courts in Texas may in any case, civil or criminal, without a participant's consent. Is there a specific paragraph we're going to?
No, just that, Judge, just the beginning.
All right. Go ahead.
And the way that I read this edict from the Supreme Court is, as long as you don't limit somebody's constitutional rights, this is what's going to be in play. This is what you guys need to do as courts. We rule over you and we're telling you what to do, as long as we don't circumvent the Constitution in these orders.
Okay.
And I'll get back to that later, Judge.
Okay.
And with that, Judge, I'm ready for argument. Well, I'm ready.
Okay.
Yeah, I'm ready for argument. It's sort of weird, Judge, because I've got to show the length of delay, and then after I show the length of delay is over 8 months and it's presumptively prejudicial, then the burden of proof and presentation shifts to the state. But just because that's a real awkward way to do things, I'm going to ask the court indulge me and let me go through my presentation of evidence at one time, and then allow the state to respond. I'm not trying to step on anybody's toes. I just think it works out smoothly.
All right, give me a minute to get my notes in order. And what I'd like to do is here, as long as everybody agrees on the dates, and we're going to go over those here in a second. We're going to go ahead and let you give your presentation, and then the state can respond. Is that okay?
No objection from the state, Judge.
Okay, Judge. May I proceed?
Nope. I'm still making my notes. Hang on. I'm familiar with the famous Andrew Del Cueto long-winded but specifically on point argument in all cases. So I'm trying to get ready for that. All right. My understanding is that the COVID problem originated plus or minus March of 2020 and is still in effect today. The offense date for this particular case is June 11th, 2020. The information was filed on or about June 23rd, 2020, and defense motion to dismiss for lack of speedy trial was filed on or about August 12th, 2021. Defense, is that accurate?
Yes, Judge. If you would also include my first request for a speedy trial occurred on June the 15th of 2020.
Okay, got it. Okay, over to you, Andrew.
Okay, Judge. So real simple, I've got to prove 4 things under 2 cases, right? And they're pivotal cases. One case was the United States Supreme Court that everybody knows, Wingo v. Barker. And then that standard was also accepted by the Texas Court of Criminal Appeals in a case by the name of Zamorano v. State, okay? And those factors are length of delay, reasons for the delay, assertion of the right, and prejudice. Those are the 4 factors that I have to prove. So length of delay, I'm going to refer back to defense exhibit number 1. The length of the delay, the time, according to the case law, occurs when somebody is either arrested or charged, whichever is sooner of an offense, right? In this case, it was 6/11 of 2020. 4 days after 6/11 of 2020, I did what we should do, what the court requires us to do. And when I say the court, I mean the Court of Criminal Appeals in the United States Supreme Court. And I asserted a right for a speedy trial. I didn't say, Judge, dismiss our case. Judge, we don't want to go forward. I said, Judge, I want to go forward on this trial. Give us a speedy trial, right? Actually set the case for trial. That's defense exhibit number 1. Then, that's when I gave the court notice, but we didn't even get a setting until August, which was 14 months later. And in August, we didn't get a setting for a trial. We got a setting to have a trial in the future, which was set 10/25, which is 16 months after I filed my original request. Okay. So in between that time, the Court of Criminal Appeals, in particular, Kevin Yeary, says I need to consistently bring up my denial of speedy trial. I can't just do it once. It's not good enough, according to Judge Yeary. I've got to bring it up more than once. So we did that on August the 13th of 2021. We said, look, we've been denied our speedy trial. So as far as the length of delay is concerned, it is over 8 months. According to Wingo and Zamorano, it is presumptively prejudicial. Now the burden of presentation and proof shift to the state. As far as assertion goes, I asserted it on 6/15 of 2020, and then again on 8/13 of 2021. And as far as the mindset or the intent, and I know the prosecutor wasn't here during this period of time, as far as being here, meaning assigned to your court, Your Honor. And again, I'm not trying to step on anybody's toes. But as of today's date, they have still not complied with 3914. And it wasn't like I was hiding the ball, Judge. I came out and filed something. And that was defense exhibit number 4 that we filed back on 12/29 of 2020. So the mindset of the state wasn't even like, hey, we're ready to proceed, right? Because they haven't even completed discovery. So then, Judge, the question is, and you raise a great point because you raised the issue of COVID, right? COVID occurred around March of 2020, and it sort of brought us into a tailspin, right? And that can be one of the factors that you can consider for the reason of the delay out of the 4 factors, but you cannot just say, COVID, I'm gonna delay you, because that's not what the emergency order allows you to do. In fact, within the emergency order, starting from the inception of these orders, the order that was in play during the time of this incident, it didn't say you cannot have a jury trial. It said you have to take measures in order to ensure a safe jury trial. And I get that Judge Rangel has come up with when he believes it's safe and when he believes it's not safe. But I want you to note, Judge, that in many jurisdictions during this period of time, lesser jurisdictions in my mind to Bexar County, right, such as Kendall or Medina or other counties around the state, they have still been conducting jury trials because they have been following the edict of the Court of Criminal Appeals. And that is putting safety measures in place to ensure people can get a jury trial and they can still continue to move their docket. Just because it hasn't happened in Bexar County doesn't mean that it couldn't happen. And then I would like to turn your attention to this, Judge.
Okay.
There is a case decided by the Supreme Court of Texas. And this case came down April of 2020. This case came down prior to the arrest of my client. Now, the facts of this case are very different than the facts of this case. This case dealt with a felony, and it dealt with your 90-day right to have a hearing, a writ of habeas corpus. And if you were denied or if the state lost, then you should automatically get bond, right? because the governor's order said, I'm not going to allow you to set bond on these, what he considers dangerous offenders. But the Supreme Court of Texas very clearly notes that the governor's executive order and any other orders do not suspend the Constitution. So your constitutional right continues even during a pandemic or a natural disaster. And there's nothing that anybody can do to circumvent it. Now, Judge, there is one case that we found on point. And that's this case. And if you'll note the date of this case, it was September 17th of 2020. It is not from our jurisdiction. It is from the jurisdiction of Amarillo. But this case is on point. And it was decided after my client was arrested, right? And this case in particular says constitutional speedy trial motions could not be denied during the pandemic on the basis of purported instructions to jury court of indefinitely foregoing non-essential proceedings pursuant to the emergency orders, right? And it further goes to say, constitutional speedy trial motion could not be denied during COVID-19 pandemic on the basis of purported instructions giving to the trial court indefinitely foregoing non-essential trial proceedings pursuant to the Supreme Court's emergency orders. There was no authority permitting the Office of the Court Administration, presiding judge of the Court of Criminal Appeals, or Chief Justice of the Supreme Court to unilaterally suspend the Constitution. A caveat in the first emergency order, which is the same caveat, Judge, in our emergency order back then and currently, right? Same caveat, subjected the restrictions imposed thereto to constitutional limitations, of which a speedy trial is one of them. And subsequent emergency orders implicitly recognize that the state of natural disaster alone could not indefinitely permit enjoyment of the right to speedy trial and provide means for trials to proceed. The Constitution is not suspended when the government declares a state of disaster that may impact the judiciary and its disposition of cases pending before it. A state of disaster alone cannot indefinitely predetermine enjoyment of an accused constitutional right to speedy trial. And then more specifically, Judge, this is how this judge ruled in this particular case, right? And I think I mean, he's not being ugly about it. He's just saying the problem is the state's ready, but the court is not allowed to conduct a jury trial because the Office of Court Administration has instructed me that I'm not allowed to conduct any jury trials until they let me know. In this particular case, Judge, the state hasn't even finished complying with discovery. And Judge, just to let you know, we are still missing dash cams of two of the three officers that are there. On top of the Office of Administration, the Chief Justice of the Court of Criminal Appeals and the Chief Justice of the Texas Supreme Court have instructed the courts, including me, that we are not to have live in-person hearings unless it's absolutely necessary and there is no other way to have a hearing, and we are not to have jury trials. And then this particular case refers back to the edict provided in Ray Abbott, the first case that I presented to you, Judge, which is a Supreme Court case. And it goes on to say, it is true that our Supreme Court ordered the courts must not conduct non-essential proceedings in person, contrary to the local, state, and national directives, whichever is most restrictive regarding maximum group size. But they also say it's still subject to constitutional limitations. The right to speedy trial being a part of both the United States and Texas Constitution, too, falls within the governor's edict. It remains alive and cannot be suspended. Yet the state of disaster alone cannot indefinitely preterminate, I'm going to mispronounce it the whole way through, I apologize, enjoyment of the right. And then it goes on to say in this case, Judge, just like my argument to you, it's not that the county in Amarillo couldn't comply with the edict. It's that the county in Amarillo didn't comply with the edict. That's what it's saying, because the Supreme Court says you can have it, you just have to follow local, state, and national guidelines, okay? And then with that, Judge, I'm gonna go back to the speedy trial. Hang on. Also in this edict, Judge, and by the Supreme Court of Texas, you were allowed to consider all sworn statements made out of court. And Judge, I'm going to stop sharing for a brief moment. Give me a second, because I forgot to download that, and I apologize for the inconvenience. So at this time, Judge, on the issue of prejudice, I would like to introduce, pursuant to the order of the Supreme Court, my client Richard Galindo's affidavit.
And this would be Defense Exhibit 6 for identification, or did I miss?
Yes, Judge.
Okay, state any objection to the
Your
admission?
Honor, the state objects on the grounds of hearsay.
Again, Judge, there's an order in
Let me read,
place.
let me read, everybody stop talking, please. Let me read the document real quick, Andrew, and then we'll talk about it. Hang on. And Mr. Del Cueto, now is a good time to ask, is there any other discovery that the defense has not received except for the notes and whatever the other little MD, whatever it was thing?
All I can tell, Judge, okay, and I'm not trying to be long-winded at all, Judge. There are two cases that have come out since the fourth court decided Secula, which is a case straight out of your court, right? And those cases are Watkins and Hallman. And in Watkins, the Court of Criminal Appeals is very clear, and it says my only duty to the court, to the prosecutor, is to ask for a request. And anything that may be material, and they define material as big subjects or subsidiary subjects, smaller subjects, anything that could be material to any issue at trial has to be provided. And I have no burden other than filing the request. All I can tell you, Judge, is I have dash cams with no adjoining front cameras. I mean, I'm sorry, opposite. I have body-worn cameras with no adjoining front cameras, but I don't know how the state is going to proceed on their case.
All
It's
right,
like
Andrew,
asking me
Andrew,
what, it's like the. go
Stop
ahead.
talking, hang on just a
Yes.
second. Take me by the hand here. MTDs is what I couldn't remember. Is that
Yes.
the correct term for the information you have not received yet?
That's one,
Gamma.
yes, Judge.
As in Mike, D as in Tango, D as in Delta, and the arresting police officers' handwritten notes. Those two items, so to speak, which could be a lot of information. I don't know.
Yes.
Those are the only two items that you were not normally provided under your discovery request.
That is correct, Judge. But even under our discovery request, we still have not been provided the normal items.
Okay, and with regard to, and this is proposed defense exhibit number 6, the affidavit of the defendant, is that correct, number 6?
Yes, Judge.
All right. I'm going to overrule the defense's objection and for purposes of this hearing only, admit the affidavit of the defendant, which would normally be hearsay, with the understanding that if he were to testify today, the defense is representing this is basically what he would say. Would that be accurate, Mr. Del Cueto?
Yes, Your Honor.
Okay, so the state objection is respectfully overruled, and I will admit that, and I will read it, and I've got it. So is everything that was prejudicial to the defendant enclosed in this affidavit would be my next question.
Yes, Judge.
All right. Keep going. I got it.
So, Judge, with my presentation of evidence and with the affidavit, I've shown that the length of delay is 16 months, way over the 8-month period, double the 8-month period. I've shown that the case wasn't even set as far as the reason for delay until August of this particular year. I've tried to show the court, according to the Supreme Court order and according to the cases regarding this particular pandemic, that is not sufficient in and of itself to say that there's not a justifiable reason for a delay. I have shown the court in 2 different documents when we asserted our right, and now again, a dismissal for warrant of speedy trial. And with defense exhibit number 6, I have shown you that it has prejudiced my client. And then I'll just be ready for argument after the state proceeds with its burden of presentation.
All right, let me ask the defense a couple of questions, and I'm going to turn it over to Ms. Galloway to respond. Probably every case in our court that was filed over 8 months ago is in the same circumstance as Mr. Galindo's case. Do you agree? I mean, we can't get them to trial per se. Most recently, I guess, technically a couple of cases have gone to trial this last week or so in the county courts of Bexar County. But before that, there haven't been any jury trials I'm aware of. Would that be accurate?
Judge, that is, if you're asking me, I do not think that is accurate. There was a time period for about a month and a half, 2 months that the courts opened up. And the only reason I know that is because we were almost every day in County Court 11, ready to pick a jury.
From my notes, I see that when you actually, I mean, obviously you filed a motion for speedy trial early on in June 15th of 2020, correct?
Yes, Judge.
But you didn't ask for a trial setting at that time. You just filed a motion for speedy trial. Do you see a distinction between those two things?
No, Judge, I asserted our right for a speedy trial. That is asking you to set a trial.
Okay.
That is what the law says I have to do.
And from your experience and knowledge of the procedures of the county courts at law in Bexar County, Texas, what would have been my earliest time period when I could have granted you a jury trial in this case?
I believe that that aside from the Delta wave, the courts opened up for approximately 2 months, Judge.
Okay. For the record, we have not had a jury trial. I can't remember the last jury trial.
I'm not saying that you, County Court 6, has had a jury trial. What I'm saying is, of course, Judge Ron Held tried a death penalty case in the midst of the pandemic. And Tommy Stolhansky has tried several cases. County Court 7 has tried several cases. County Court 13 has tried several cases. And there are other people in the Zoom meeting with me, like the Honorable, and I hate to even use that word, Ernie Acevedo III, who can also say that there have been plenty of trials in Bexar County.
Okay. Clarify this for me. You filed a motion for speedy trial.
No, Judge, I filed a request for speedy trial. I'm putting the court on notice that I want a speedy trial.
I understand. And that was June 15th, 2020, correct?
Yes, Judge.
So on 8/16/21, that's the first actual time this court has set a jury trial date. Is that correct?
Let me look it up, Judge. That is correct. On 8/16, that's when we got our notice.
All right. Somewhere early on, there would have been an arraignment docket. Do you recall participating in an arraignment docket on this particular case?
Yes, Judge, those were waived.
And oh, those were waived. Okay. So on 8/16/21, when this was actually apparently physically set for a jury trial in this court, which probably would have been what, before now, because we've had to keep moving it up because of the Supreme Court orders. Do you agree?
I say it one more time, Judge. I'm sorry.
I said the case, either by your request or I don't know by what other reason it would have been other than your request. This case was actually set on our trial docket for a jury trial on or about August 16th, 2021.
That is correct, Judge.
Okay. And did you make any formal motion to set it for a jury trial, or how did that happen? Do you know?
No, Judge, I think it was just set, but I don't want to misspeak. I think Pat said it, but I think she would be the person to tell
The
you.
only reason Pat would have set it for a jury trial is either you requested it or I ordered it. And I might have talked to you and you represented you needed a jury trial, and I just would have told Pat to set it. Does that sound like something that
Maybe,
happened?
Judge, but I don't want to misspeak. I want to be accurate, Your Honor.
Okay, well, I don't know how to get any more accurate than that.
Well, I'm saying, I'm not saying that did happen or it didn't happen. I don't have any memory of that, Judge.
Okay, I understand. Okay. I've got the defense side. State, and I know this is going to be very difficult, but if you could briefly state the state side, I have it figured out. I think
Judge, you know what I think? To be very honest with you, if you look at the date that I filed a motion to dismiss for one of speedy trial, that probably prompted it being set for trial.
You're right. 8/12/21 I have as a motion. You filed your motion to dismiss for lack of speedy trial, and 8/16/21, 4 days later, set for jury trial. So you're right on the money on those two. That would make perfect sense. Those are puzzle pieces that fit. So state, I think, not only in Mr. Galindo's case, but probably every other case we have that was originally filed back then, all the circumstances remain the same during the COVID problem. So I understand the time delay. I understand the dates of the information being filed. I understand the dates of the assertion of right to speedy trial. Prejudice is the only issue I need discussion on from the state. I have the others figured out. But if state wants to briefly address any of the others, you're welcome to. But that's all kind of set in stone. So go ahead, state, over to you.
Your Honor, we would ask you to take judicial notice under Texas Rule of Evidence 201, Section B, of the facts that there was a pandemic, as you stated, from March 2020 until this date. And we would also ask you to take judicial notice of the standard operating procedures of this court, that the defendant is not required to appear at the arraignment docket. Your Honor, defense counsel has stated that he did request a speedy trial on June 15th of 2020. However, based on our system and mainframe, Mr. Del Cueto or some of his associates attended arraignment settings on July 17th. That was reset. There was another docket appearance on October 8th, which was reset, and January 15th, which was reset. At that time, it does not appear that a jury trial was formally requested during the arraignment docket hearings. And then, Your Honor, defense filed the motion on December 29th, 2020, requesting additional discovery. The state has turned over all the discovery that is in its possession, and we would argue that that is a reason for delay that weighs against the defense. Your Honor, the defense has argued that other counties, such as Kendall County, has conducted jury trials during this pandemic. However, we would argue that Bexar County is a bigger county, and that's the reason that this court has not conducted jury trials since the inception of the pandemic. Your Honor, the reasons for delay would be the pandemic, overcrowded courts. And Your Honor, the defense has not displayed sufficient prejudice in this case. Mr. Galindo, the defendant, has not suffered any extraordinary prejudice in this case, Your Honor. He was only incarcerated for 1 day. He was granted a bond and release. Your Honor, in the affidavit, it states that Mr. Galindo is afraid to apply for a new job. He has not presented evidence that he lost his current job because of this. And Your Honor, we would further argue that he has not been prejudiced by having to attend the arraignment dockets. So we believe that prejudice has not been shown, Your Honor.
Okay, anything further, Mr. Del Cueto?
Yeah, Judge, if I may, just to give you an example, Sheila Harrington, SHEILA space Harrington, HERRINGTON, and the cause number is 649747. That was set for trial 2 months ago, or 3 months ago, in County Court 11. We were ready for trial and the case got dismissed with a jury in the hallway. So several cases around Bexar County even have been set for jury trial, and jury trials have proceeded.
Your Honor, if that's the case, Mr. Del Cueto could have filed to transfer this case to a court that was conducting jury trials. This court has not conducted jury trials since the inception of this case. And furthermore, the case that he just referred to is irrelevant in our case because we do not know the reason that it was dismissed.
I'm not saying that there's a good or bad reason for dismissal, Judge. I'm just saying if you look at CGIS, or if you look at the Bexar County website, you will show that we were set for trial, a jury trial. We were in the courtroom with a jury in the hallway and the case was dismissed. I didn't know that I could just willy-nilly transfer cases out of your court, Judge, because I've tried before and it's been very, very, very difficult. But if that's the case, then I've got a list. No offense.
Mr. Del Cueto, how many jury trials, criminal jury trials have you personally participated in since March of 2020?
Oh, Judge, I have prepped 4 personally jury trials. In 2020, no. In 2021, I have prepped 4 jury trials and 4 cases have been dismissed.
I'm sorry. So you actually tried before a live jury, 4 jury trials?
No, Judge. All I'm saying is there was a jury panel. The state was not ready and the cases were dismissed.
Okay.
But
Have
there
you
were
tried
live
any
jurors.
in-person jury trials since March of 2020?
In 2021, not 2020, 2021.
And how many had you tried in 2021 in person?
None, Judge, because they've all been dismissed.
I understand. Okay, I got you.
All right, I'm not saying they didn't occur. I'm just saying I didn't get a chance, thank God, because they were dismissed before we had to select a jury.
I understand. Anything further, Mr. Del Cueto?
No, Your Honor.
State anything further?
Nothing further, Your Honor.
Cause number 641136, style of State of Texas versus Ricardo Galindo. Notwithstanding the defense superb, concise, lucid, and cogent argument points, the court respectfully denies the defense motion to dismiss for want of speedy trial. Anything further from the state of the defense?
Yes, Judge, I would request that we be first up on Monday.
You are absolutely first up whenever we start taking up jury trials. And also, state, I would like within 30 days, because I know you're having tremendous problems with the San Antonio Police Department and the Bexar County Sheriff's Department. Is this an SAPD case, Mr. Del Cueto, or
It
Sheriff?
absolutely is, Judge.
Within 30 days from this day, I want the answer on whether or not the MTDs, is that correct? MTDs, all MTDs pertaining to this case and all handwritten notes from the arresting officer pertaining to this case either be provided to the defense or have an explanation of why they can't be provided to the defense. Okay with the state?
Yes,
You've
Your
already
Honor.
had a year and a half or something? All right.
Judge, it says on the case detail report that we're set for a jury trial on 10/25 of 2021. We're announcing ready.
And let me ask this, State, are you ready for trial on this case? To say within 10 days? And if you don't know the answer to that, I want to know within, say, 48 hours, well, today's Friday. Let's say by next Wednesday at noon, whether you're actually ready immediately to go to trial on this case so we don't waste everybody's time.
Yes, Your Honor, but I'm kind of confused because are we going to proceed to trial without the evidence that Mr. Del Cueto's requesting? Because that's
No,
not
but
going to be ready.
I want to know if for some reason you can't prove this case, you might as well just dismiss it. We'll just move on. If you can prove the case and you have all your witnesses, then you've still got 30 days to get them the evidence they need. But even without that evidence, if you've got some sort of tactical problem that nobody's aware of except you, we need to know what it is. The defense needs to know, they're demanding a jury trial today. They're ready. Bring in the first, that kind of deal. So we need to know from the state whether you really, truly, no kidding, are ready to go to trial or not. And that's by Wednesday. Doesn't that give you enough time next Wednesday at noon?
Yes, Your Honor.
Check on your witnesses and whatnot. All right. Anything further from the state or the defense on Mr. Galindo?
No, Your Honor.
All right. Thank you. Y'all are
Thank you, Judge. Thank you, Judge.
And is Pat with us today?
I'm here, Your Honor.
All right. We're moving Mr. Galindo's case to number 1 on our hit list, if as and when we have a hit list on our jury.
Yes, Your Honor, I have it already.
What do we have an actual trial date set right now? Is it like January?
Yes,
or
it's
something?
Monday. It's the 25th of October is the trial date that he set for at right this minute.
Okay.
Yeah.
Well, leave it. What's today? 15th. We'll know from the state on Wednesday whether they're really ready to proceed, and it's the defense decision whether or not they want to proceed without this MTD and notes evidence if they wanted to, that kind of deal.
Okay,
right.
Your Honor.
All right. Mr. Acevedo, let me find your stuff.
And Pat, I think my guy got stuck in the breakout room. Are you able to bring him
Okay,
back?
I'll get him back. I'll get him back. Hold on.
You need more time to chat with your client, Ernie?
No, we talked and sorry. I
He
was
should be
late.
coming back. He should be coming back.
Yeah. On that note, I
If
did
not,
have,
I'll go in there and get him, but I hit main room, and normally when I hit main room. All right, let me go in and get him. No.
there he is.
Yes, ma'am.
Okay, hang on. Let me see if I can find my documentation here. Here we go. Okay, this is cause number 611-3448, State of Texas versus Scott Mormon, represented by Mr. Ernest Acevedo. This is a motion to set aside information and failure to afford constitutional right to speedy trial. Mr. Acevedo, would you please outline for the court and the state the basis of your motion?
Yes, sir. In kind of quick outline form. And I think I can present this case a little more concisely than the previous one. And we certainly have some different circumstances, Judge. This case was originating March 28th of 2019, basically a little more than a year before the pandemic. It's been more than 2.5 years at this point. And so we had requested a speedy trial on this case, April 14th of 2019, April 15th, 2019. So we are now at 2.5 years ago that we requested a speedy trial for Mr. Mormon. This case was originally in County Court 2. We have trial settings where we were set before the pandemic in February of 2020. There were settings from March of 2020 trial settings. There were settings from April of 2020 and May of 2020. And admittedly, I think that's when the pandemic reset started happening. And then there's also been a vet court application, which has been one of the most frustrating vet court applications I have ever seen, because I believe we are now about a year and a half into trying to see if he could get track one in vet court. But his records are in archives, and the VA, I've been told, was shut down for records. And it was all kind of confirmed with vet court that everything Mr. Mormon has done, everything he could possibly do to get these records. But because of various reasons, they cannot get the records needed for his application. And we've been to court several times on that matter as well, where the vet court people have said, yeah, we're waiting on documents. And like, you know, he's done everything he can do.
Let me stop you there for a second. Do we have an actual copy of a DD 214 for Mr. Mormon?
He has to answer those questions. He knows the forms better than I do, Judge. And I don't mind him answering those questions for you.
All right, great. Hey, Mr. Mormon, do you have a copy of one or more of your DD 214s? I don't know how many you have.
Yes, sir. I can barely hear you, sir.
I'll crank it up. You're deaf like me. All right, go ahead.
Yes, sir. I have a member 1 copy, and Joshua told me I needed to turn in a member 4 copy. I've never had a member 4 copy, and that's what I applied for the whole packet with what turns out to be the National Archives, to where I'm not even in processing yet.
All right.
And
What did you do in the military, sir?
I was at
What did you do in the military?
I was 11 Bravo 327th Infantry, sir.
Are you old enough for Vietnam?
No, sir. I missed that.
Did you go to any wars anywhere?
I was 87, 89. No, the Kuwait deal started right after I got out.
I got you. But you got an honorable discharge, correct?
Yes, sir.
Okay. And we have copies in the VTC. Josh or somebody has copies of the documents that you currently have, not the ones we're looking for?
Yes, sir. Of the member 1, DD 214.
Okay. Ernie, I'll look into that. This is the first I've heard of it. Obviously, it's been a long time. I don't know why it never came on our radar before. But let's talk about the speedy trial business now.
Yeah, and Judge, I mean, I'll tell you what separates this case from a lot of motions that are being presented is that Mr. Mormon does have significant loss from this case being pending for so long, probably the most I've ever seen. And I do want to present his testimony because we do have a case that's 2.5 years old.
All right, let me ask you this. Can we specifically go to the point of prejudice to the defendant? Because I think in almost every case in this court, every other issue with regard to time, we know the situation on. You know, COVID has slowed everything down, and but everybody, this is the much older case than the last one. So can you talk to me about prejudice that was suffered by Mr. Mormon as a result of the delay?
Yeah, Judge, there is extreme prejudice in this case, and I would like to call Mr. Mormon as a witness to explain what he's been through for the past 2.5 years.
Mr. Mormon, please raise your right hand for me, sir. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Defense your witness.
All right. Mr. Mormon, I'm going to ask you some questions. Please make sure you hear me. If you don't, please ask me to rephrase, okay?
Yes, sir.
All right. To kind of speed things up, I'm just going to kind of go over the basics. Did you get arrested on this case approximately March of 2019?
Yes, sir. 28 March.
All right. Did you hire me before your first court date to fight your case as best as I could?
Yes, sir. Yes, Ernest.
All right. And were your instructions to me to fight your case however we could, because you wanted to see if you could beat your case, you know, the way you were constitutionally entitled to? Were those your instructions?
Yes, Ernest.
All right. Did you come to all the court appearances that you were asked to come to?
Yes, Ernest.
Did we have trial settings that, you know, I told you, hey, we're set for trial, we're going to court, and you were there?
Yes, Ernest.
All right. Did we also talk about the options of vet court where like there'd be a possibility of getting your case dismissed if you could get into vet court?
Yes.
All right. And so you've been trying to figure out one way or another how you could possibly fight this case or get it dismissed through vet court. That's been the process you've been going through for the last 2.5 years, correct?
Yes.
All right, so now I want to ask you a few questions about like what's happened. Okay, so March of 19 is when you got this case. Had something just happened to your job just a few weeks or a month before that?
Yes, I was project management, HEB, almost 12 years, and we had a pretty much a mass layoff, and I guess 40 of us or so old timers got laid off. I was laid off on 1 February of 2019.
All right, so now,
Go ahead.
okay, so you got this case in March, and this was a time where you were going to have to find a new career. Is that correct?
Yes.
All right. How much were you making, just approximately, when the layoff happened?
With HEB around 75,000 and entitlements and all that. And then, you know, I had side work I did also, but.
All right. So in March of 2019, did you started working with like headhunters to start finding a job in your field that was comparable?
Yes.
All right. And if you had to guess how many applications for jobs you put in over the past 2.5 years, I mean, what do you think that number might be?
Probably 100 or so. I mean, I'm a lot, 100 or so, I would say.
Now, have
everything.
Okay. Well,
everything that came up that I thought I could, you know, nail to be employed.
All right. Now, the headhunters, did they give you explanations why you were getting like through first, second interviews, but then when it came to the hiring decisions and background checks, that's when you stopped getting callbacks?
Yes,
what was
they
reason that they gave you why that was happening over and over and over again?
Was because of the arrest on my county court records.
What did they think of your qualifications and you know, for the positions you were applying to? Did both of them have the same opinion on why you weren't getting past the last interview with these companies?
Yes, and yes. Answer to that question is yes. And I have well over 35 years of managerial project management experience in the construction trade, and my resume is exemplary. And I was told that, you know, by each recruiter, even the companies that I was applying for, that I was a shoe-in, and they were really excited about getting me on board their companies. And then, you know, once it hits HR, it's over.
So it was every time when they got to the background check, that's when everything would just suddenly turn around for you?
Yes, sir.
All right. And so, like, as far as financial consequences, what have you lost over this past 2.5 years, because it's been so long with this one misdemeanor case pending?
Just about everything. I've been homeless, all the way to homelessness.
Did you lose your house?
Yes.
Did you lose all your savings and pretty much retirement and everything you could kind of cash out?
Yes.
Did it get to the point where you have actually been homeless with like no paid place to live, trying to struggle to find some place to sleep?
Yes. If you can see this old pickup truck I'm driving, this was home.
All right. Now, in addition to that, as far as it comes to delay, you know, the vet court program was a way where we were hoping potentially you could have your case dismissed through the vet court. That was an option for you, at least, right?
Yes.
Can you tell the court how difficult it had been to even get your application in? How long ago did you start trying to get this application in?
Ernest, I don't have my file in front of me. I'm out on a job site, but I believe
Hold on.
year first, the beginning of last year when I first talked to Joshua, and then this came down. I don't want to misspeak, but you know, I know this has been going on. It's got to have been going on at least a year trying to get this thing through my records and so on and so forth. But I don't have the exact timeline in front of me.
Have you done everything you possibly could could do to get the records and just been stonewalled by the government?
Yes, because I felt confident we'll be accepted to the program. And I think I have a lot to offer them as well. And I just can't get my records. That National Archives there's no movement there.
All right. Now, additionally, you've had a breath testing device now for 2.5 years, haven't you?
Yes, sir. I originally had one in the truck, and it was removed. And then when CC6 picked up the case, it was part of their criteria that I have the in-home device, which is with me at all times.
So how much does that cost you per month?
Around $90.
And you have been paying that for, I guess, 30 months at this point. So I guess it's more than about $3,000 worth.
Yes, it's just, yes.
All right. Now, can you tell me about just the anxiety that not being able to get a job because of this misdemeanor case pending for this long to the point of homelessness? How has it affected you psychologically for the past 2.5 years?
Well, my self-worth is, waning, I would say. I've lost everything, Ernest. I don't want to get choked up. I've always worked hard, done good for people, tried to help people, and then I find myself having to have help. And I just think that if it wasn't for the good Lord, I wouldn't be sitting here right now. I'll just say that.
Well, you've told me about depressive feelings where, I've tried to help you and, try to get you to a professional because you've felt to the point where you've thought about hurting yourself. It's gotten so bad. I mean, you've told me that stuff in the past, haven't you?
Your Honor, I'm going to
Yes.
object for leading, Your Honor.
Overruled. Go ahead.
You can answer that question.
Yes. Unfortunately, yes.
And we've had those conversations where we've talked about like, hey, there is an end at the light of the tunnel somewhere, and we'll get you there. We've had to have that conversation, you and I, several times, haven't we?
Yes, sir.
All right. And as far as the dates go, you have been asking me to fight this case for 2.5 years, and you have been making all your court appearances, and you have been to trial settings for a year before COVID started in this particular case, haven't you?
Yes.
Are there any other ways it's affected you that I haven't talked about yet that you think it's important for the court to know about?
Just there's just so much I can't it's just devastated me, emotionally, financially. If it wasn't for my good faith, I just wouldn't be here, I went from a helper to being the helped. And it's just devastating.
All right, I'll pass the witness, Judge.
State cross-examination.
Mr. Mormon, when you were arrested for this offense, you only spent 1 day in jail. Is that correct?
I believe I was released the morning of the 30th.
So how many days did you spend in jail?
Well, I didn't hit jail. It was the annex, the big holding room.
Yeah, correct, sir. How many days did you stay there? 1 day?
Well, I guess that happened around late at night on 28 March. And I believe I was released way early in the morning on the 30th of March.
Okay. And so you stated that you were laid off from your job at HEB before this case occurred, correct?
Yes.
And about how many other people were laid off from HEB?
I would say 35 to 40 in 2 different departments, all mid to upper management in construction division.
Okay. And did all of those people have cases pending, or what was the reason that they were laid off?
I don't know about their personal lives or their cases pending at all. I can't speak on that.
Okay, so what was the reason for the layoff?
I believe they had some new upper management come in that wanted to do things differently and switch from a regular project management theory to what's called agile project management.
Okay, and so you would agree with me that you did not become laid off because of this case, correct?
Yes, correct.
Okay, and so earlier you mentioned that while you were employed with HEB, that you also engaged in side work. Can you please explain to the court what side work that is?
That would be consulting on general contracting. Basically referring people looking for construction work to the viable subcontractors to do their work.
Okay, and was that through HEB or something that you do on your own?
That's something that I did on my own.
Okay, and were you able to continue doing that after you were laid off?
No.
And why is that?
Well, my situation changed and I wasn't able to. My mental stability changed and I wasn't able to.
So your layoff from HEB prevented you from engaging in your side work, is that correct?
No, I would say this unfortunate incident we're here today for had to do with that.
Okay, so between the time that you were laid off from HEB and the time that you picked this case up, were you still engaging in your side work?
I'm sorry, repeat the question.
So between the time that you were laid off by HEB and the time that you were arrested for the offense of DWI, were you engaging in your side work of consulting?
Actually, for that little bit less than 2 month period, no. I had, from the layoff, I was, kind of devastated, and I just I guess I would say I was in shock.
Okay, so it's
because I
fair.
fully plan on retiring with HEB.
Okay, so it's fair to say that the layoff had some type of bearing on your inability to engage in side work, correct?
No, no, I don't think so.
So what was the reason that you did not engage in side work for the 2 months?
Well, no, I'm sorry. Yeah, now that I understand what you're asking, I guess it did.
Okay, thank you, sir.
Yeah.
And you mentioned earlier that you were working with headhunters. Can you please explain to the court what types of jobs that you were applying for?
Yes, ma'am. I do construction management, both commercial and residential.
And so is it fair to say that you were only applying for jobs that have a direct correlation with your job title at HEB?
In a sense, I'm a project manager with or without HEB, and I have been for over 30 years. I was only with HEB for almost 12.
Okay, and did you submit
Right now-
application? Go
Right
ahead.
now, I'm a licensed home builder with the city of San Antonio, and I get no work because this thing is on my record. And when anybody looks me up and finds that, you know,
Okay,
it's a no-go.
and so have you applied for any jobs that are outside of the managerial role that you are qualified for?
Yes,
And can you explain what types of jobs those were that you applied for?
menial labor jobs, power washing, painting, you know, those type jobs. And I've been fired with over 3 of them because of this device that I have.
Okay, so you have been able, since you were laid off with HEB, you have been able to secure additional employment, correct?
Yes, ma'am. Not enough to pull me up out of the gutter, though. They don't pay enough.
Okay. And so you stated that you're at a job site currently. Can you please explain to the court how you are currently employed?
I'm employed on a contract basis with Broad Shield Custom Homes
Okay. And
as a
I'm
project manager, and I'm building custom homes.
okay, so you are currently employed, correct?
Yes,
Okay.
until they find out about all this, and then it'll be over. I'm quite sure of it.
And you stated during the direct examination by your attorney that you hired Mr. Ernest Acevedo to represent you back in 2019 when you were accused of this offense, correct?
Yes,
And Mr. Acevedo has maintained representing you through the duration of this offense, correct?
yes, ma'am.
And you were able to pay Mr. Acevedo and keep him on retainer to represent you in this offense, correct?
Yes, from the time that it happened, I still had, I was living off of my severance pay, and I took some of my severance pay and paid Mr. Acevedo.
No further questions from the state, Your Honor.
Mr. Acevedo, redirect.
Just a clarification question. Mr. Mormon, had you ever had trouble finding a job, you know, in more than a month or two if you switched from one company to another?
No, sir. I always had another job lined up before I would leave one.
All right. So, I mean, in this contract that you're working right now, that's very recent, isn't it?
Yes, this is my 5th week, actually.
All right. And so, I mean, this trouble you've had that you never had before in your life, and you've been told by the headhunters, is because managerial positions and pending DWI cases just don't mix as far as the hireability. Is that your understanding?
Yes, Ernest.
All right. That's the only clarification I had, Judge. I'll pass the witness.
State anything further?
Mr. Mormon, so how long were you employed with HEB?
I'm sorry, it's echoing. Can you please repeat?
Yes, sir. How long were you employed with HEB?
A little under 11 years, and I believe around 6 months, a little under 12 years.
Okay, so it's fair to say that you did, during that almost 12-year period, you did not have to look for additional employment, correct?
Yes,
Okay, And in addition to the job that you are currently working at right now, you stated during cross-examination earlier when I spoke with you, you stated that you previously had 3 other jobs in which you were fired, correct?
Yes, let go. Yes.
Okay. Thank you, sir. Pass the witness.
Nothing further.
Mr. Acevedo, got a couple of quick questions, and I'm requesting permission from both the state and the defense to call Josh Childers, who's the project director for the Veterans Treatment Court, to establish what exactly happened with regard to Mr. Mormon's application to the Veterans Treatment Court in County Court 6. Is that okay with you, defense?
Yes, sir.
And is that okay with you, state?
No objection, Your Honor.
And I'm unaware, I'm assuming this is a DWI case initially, Mr. Acevedo, is that correct?
Yes, sir.
And it's just filed as a straight DWI, not greater than 1.5, not a second, that kind of thing?
It's filed as a greater than 1.5, Your Honor.
Oh, greater than 1.5. Any accident or injury, Mr. Acevedo, in this case?
There was an accident, Judge, a minor accident.
Did insurance cover any possible damages, et cetera, et cetera?
Yes, he was insured, Judge.
Oh, wonderful. Okay. At this time, I'd like to call Mr. Josh Childers, who is currently in the position of Project Director of the Bexar County Veterans Treatment Court. Mr. Childers, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Basically, before I turn it over to the state and the defense, what we're interested in is Mr. Mormon's situation. We understand he was originally had a DWI filed in County Court 2, I believe, and ultimately, because he's a veteran, it was transferred to County Court 6 so he could apply to the Veterans Treatment Court. And it's sort of hazy, but apparently the staff in the Veterans Treatment Court and Mr. Mormon were unable to get the correct documentation, which I assume are DD 214s or thereabouts, to actively and correctly look at his application and either say, yes, you're in, or no, you're not. Can you please clarify for that? And I'm going to ask permission to let Josh testify in the narrative, and then you guys can ask questions of Mr. Childers also. Go ahead.
Yes, sir. So the bottom line is Mr. Mormon has been unable to procure a service record to include a DD 214 for us. We originally met Mr. Mormon with Mr. Acevedo in the first 2 weeks of March 2020, prior to the COVID lockdown. An application was given with instructions. Mr. Mormon did follow up with a few phone calls after that application was given, but due to everything that was going on, there was more or less a period of time that there was no communication that we received from Mr. Acevedo or Mr. Mormon. It really did not pick back up until January of 2021, at which point we gave information to Mr. Mormon about how to procure his DD 214 through the form this.
Excuse me, Josh. Could you turn up the volume? It's kind of low.
Is that better?
Yes.
Okay, I'll just get closer to it. So we gave instructions of how to procure his DD 214 using the standard form 180. Mr. Mormon did submit for that. However, through April and May, it was not returned back, at which point we closed his application process, until at which time he was able to procure his DD 214. As of today, we have not received that. Based on the way our grants are set up through the Texas Veterans Commission, without proper DD 214, we cannot allow veterans to come in the program just to ensure that we meet the standards of the state. With that being said, I don't know if there's been any updates since April or May, since our last communication, if he was able to procure those documents, but my assumption is no.
Mr. Childers, have we had other applicants to the Bexar County Veterans Treatment Court that were unable to get copies of their DD 214 document?
We have had no veteran who has not been able to procure. That is not stating that it has not been an issue with a involved. However, we've had no veteran who has had an issue going back this amount of time procuring their DD 214.
And is the standard operating procedure currently in the Bexar County Misdemeanor Veterans Treatment Court you give a defendant information on who to contact and how to get a copy of his DD 214 document.
That is correct.
But then we don't take any further action on the VTC side. It's up to the defendant to get the document. Is that how it's normally going on these days?
That is the only way it can be done based on privacy information. The individual has to request it themselves.
Okay. Mr. Acevedo, do you have any questions for Mr. Childers?
No, well, one question is the age of service, because I know Mr. Mormon's service is from the late, from the 80s. And I know one of the problems he's told the court is that it's in some kind of archives that's been kind of shut down, where they're not doing anything during COVID because they've been shut down. Is that something you're aware of as being a little bit of a different circumstance of people that have more current military history that might not be archived?
That is not a true statement. The way that that veterans request their information is funneled through their service branch, not necessarily through an archive system. I do not know what the standards of operations are for those organizations during the COVID shutdown. However, we've had multiple individuals during the same period of time, some of which were in the same era of service, who have been able to procure their DD-214s.
That's the only question I had, Judge.
Okay. State, have you got any questions for Mr. Childers?
Mr. Childers, you stated that it's the standard operating procedure of the VTC that applicants are required to, that applicants are required to provide their DD-214. Is that correct?
That is correct. For all veterans, a DD-214 is required, with the exception of active duty who have different requirements for that, or those who never served, whose DD-214 wouldn't necessarily be their final document for those people in the National Guard or Reserves. The documentation is a requirement for us to have them apply and be accepted into the program.
Okay, and that DD-214 is required so that the Veterans Treatment Court program is in compliance with state regulation, correct?
Correct. As a Veterans Treatment Court taking grants from the Texas Veterans Commission, we have to not only see that there is a service record, but the nature and the character of their service record. So we have to confirm if it was an honorable discharge or a discharge of a different kind.
Okay, and to date, Mr. Mormon has not provided his DD-214, is that correct?
That is correct.
Okay, no further questions, Your Honor.
Okay. Mr. Acevedo, do you have any further questions for Mr. Childers?
No, sir. I would just like to, now that we've had this testimony, I'd like for Mr. Mormon to be able to explain exactly what he has done to try to get this information.
Sure. Mr. Mormon, go ahead. I remind you, you're still under oath. Go ahead, sir.
Yes, I would like to add that I've done everything that I was given to do to get the member 4 copy, and the whatever it was, the link that I was given that I got onto, filled out the application, that's what bounced me to the National Archives. I've done everything that I know to do to get the member 4 copy. And maybe it could be that these other people that were in my era already had their member 4 copy. I did not. All my records were lost in a flood in Westminster, Texas, back right after I moved down here in 2005. And luckily I had the member 1 copy, which apparently is, doesn't work.
What have you done with trying to get it from the archive? I know you requested it. You told me that that's where they sent you next. What have you tried to do with them over the last, months to try to get it?
I've tried calling numbers, and there's no response from that place.
All right. I'll pass the witness, Judge.
State, do you have any questions for Mr. Mormon?
Mr. Mormon, about how many times a month would you say that you reach out to obtain this document?
I check on there a couple of times a week, because this whole thing, my life is at a standstill here. It has everything to do with me moving forward.
Okay. Pass the witness, Your Honor.
No further questions, Judge.
Okay. Josh, let me ask you one more question with regard. Mr. Mormon keeps referring to a number 4 document. Do you have any idea what we're talking about there?
Yes, sir. So a DD 214, which is your record of service, has two copies. A member 1 copy, which will not show your character of service. So for instance, an honorable discharge or a dishonorable discharge or a general under honorable conditions, it is not shown. For us to be able to verify not only time in service, but character of service, we must get the member 4. The member 4 delineates what the character of service is. And for us to actively apply and be accepted into the program, we must get the member 4 copy. And so anytime a member 1 is given to us, we then recognize that this veteran needs to go and get a member 4, and we give them the information. So.
Okay. And with regard, hang on just a second, Mr. Mormon. With regard to Mr. Mormon, we have absolutely no documents from him other than the actual application to the Veterans Treatment Court. We have no DD 214 copy, no other military documentation of any kind on him. Is that accurate?
I have no character of service. I believe he did give us a member 1 copy. If you can give me one moment, I can pull up his record in our system and see what he provided.
Yes,
Mr. Mormon, go ahead. Did you have something you want to say with your attorney's permission? Ernie, is that okay?
Yes, sir.
All right. Mr. Mormon, did you have something else to say?
yes,
Go ahead, sir.
yes, sir. I do have in the frame my honorable discharge certificate, and I believe it was signed by the adjutant there at 101st. And it states on there it states on there honorable discharge.
And that's probably, we have a copy of that probably somewhere. Is that true?
No, that was not part of the application, so I
Okay.
didn't turn it in,
Okay.
but I can search.
Oh, shoot. He just lost his signal.
Your Honor, I'm thinking that Josh had to, in order to get all the information regarding what he had on Mr. Mormon, he had to get off to do whatever he needed to do. So he should be coming back.
You talking about Mr. Mormon? Or you
No,
talking about
Josh, oh, there he is. Okay,
Here,
all right.
my client disappeared. Oh, here he's logging back on. There he is.
All right. I've got all the information I need on that aspect of it. Josh, in the future, when we have an applicant for the VTC and we tell them what they do to get the document and it takes more than a normal amount of time to do that, I want you to bring it to my attention because I'm going to talk to their attorney and or appoint an attorney to help them do it. Some people are just not capable of going through the red tape of the government to get what to you and me is a real simple process normally. So in the future, if we have someone like Mr. Mormon in that category, I want to know about it so that we can assist him in some way to get the documents or at least find out why we can't get the document. A lay person just has a hard time navigating all that federal hocus pocus.
Yes, sir. And for the record, we did include his attorney on updates throughout the process.
Ernie, did you have the ability to try to help him get these documents at any point in time?
Judge, it might as well be in Greek for me. I did not serve, and the numbers and the jargon that y'all use, I am completely.
You would have had to call him with them sitting there. They're not going to talk to you, so to speak, even as his attorney, unless he's sitting there so that they're giving the information to him. So it's a problem. There's no doubt.
Yeah, I've never made the attempt. Every client I've represented who was a soldier has a much better chance of getting through it than I do because I don't know who's who. I don't have any idea what the levels of command are for getting this kind of stuff. And so admittedly, I will concede that I am useless in trying to navigate this area without training that I've never been given.
And it's just all administrative, but it's all, you go through people and everybody tells you no until you find the one guy that tells you yes. And that's what
Outside of it, it would probably be a good 1 or 2 hour seminar if there is a lawyer who really knows the system well, if they could put together a slide or give us instructions for people that are completely unfamiliar with how to do this stuff. I bet it would be well attended mean, because I don't have a lot of vets that I handle, but probably 20 of them right now. And I mean, it is important at times. And again, I don't know what to do on that side. I don't do it in the courtroom, but not with the military.
I got you. Do we, can you call Mr. Mormon on his cell phone and see if he's able to sign back in with us?
It says Scott's iPhone 1 is there. That's him. I mean, he's back on.
Mr. Mormon? Okay. Mr. Mormon, can you hear us, sir?
If you can hear us, you have a very bad signal. You're completely choppy. And I can't hear what you're saying, but he is back on, Judge, obviously, but he's having some kind of signal issue.
Well, technically, we don't need Mr. Mormon except to testify as a witness to be here anywhere. From my perspective, you might want to have him here, but I'm ready to hear final arguments briefly on both sides and rule if with the defense permission without having him present, we can do that. Otherwise, he's back. Maybe we can get him to hear us at this time. Mr. Mormon, can you hear us yet, sir?
Judge, like he has testified and he's been here at the setting for argument. I don't think it's necessary that he be here just for the purposes of this motion. I am prepared to argue and I don't object to him being here partially with the phone trouble he's having right now.
All right. So it's my understanding the defense is waiving the actual presence of the defendant at this point in time. Is that correct?
Yes, for this part of the hearing, Judge. I know he's having phone troubles. I understand that, but we are ready to proceed on the argument.
Both sides, just to let you know, I've already got a plan. I understand all this stuff. It's all been very clear on this one. The big issue is it's been proven that he has 31 months, which is 3 times the minimum 8-month presumed time delay for speedy trial to kick in. The reason for that is obviously what we've been going over for the last 30 to 45 minutes, and the VTC issue was a large part of that. So if you'd like to talk about anything else, I think the defense has established the prejudice side of it very clearly. And just being on a Smart Start mobile device for 31 months would be a problem, I think, in my opinion. But so Arnie, based on that, go ahead.
Yeah, Judge, we are at almost 4 times the delay. And so yeah, that's pretty clear. We have additionally 12 months with jury trial settings, 4 or 5 jury trial settings prior to the COVID problem. And so that alone is enough to trigger the 8-month and 4 trial setting part. The reason for the delay, certainly, I think there is government delay from the first year. Admittedly, constitutional rights were not suspended, so the rest of the time counts as well. Mr. Mormon, I don't think is responsible for the delay on any level. He has wanted to fight the charge. And from everything I could tell, Judge, he has tried everything because we do communicate. And then the biggest issue is just that the harm in this case, Judge, I mentioned at the start and opening that I thought it was one of the worst scenarios that I've ever seen for somebody with a pending DWI first case that I've ever seen. He did lose everything. He's never not had a job, Judge, in his whole life. And admittedly, he picked up this case right after a layoff, but then he is pretty much gone 2.5 entire years without a full-time job anywhere near his level of experience. And that had never happened before. There's been testimony that more than one headhunter has told him, you're overqualified, you're a shoo-in for this job. He gets through all the initial interviews because he is. And then when he gets to the last step of the HR and they run his background, all of a sudden they tell him no. That's happened over and over and over again. The testimony is that has been because of the pending DWI case. On top of that, Judge, you have the harm of having a mobile device for 31 months, Judge. A standard probation is 12 months. A standard device is 6 months. He has gone over, basically almost triple of what the punishment would be. He's already been punished more than the maximum as far as everything that's happened. But losing your house, losing your livelihood, losing your self-worth, getting to the point where, admittedly, Judge, it's very private, but he and I have had talks about, him wanting to hurt himself and me trying to say there's going to be light at the end of the tunnel somewhere. We just have to get through it and buckle down. He's had a job now that he's had for 5 weeks. He's trying to do the best he can so he can maintain that job and maintain some income. But Judge, clearly, in this one particular case, the amount of harm that Mr. Mormon has suffered has been greater than any possible punishment that could be given to him in a DWI first case. And on that basis, Judge, we are asking you to grant the motion and see if Mr. Mormon can regain some of what he's lost by being allowed to be a free person in the state again without this pending case.
State?
Your Honor, in this case, the state has not made any deliberate attempt to delay trial. Your Honor, this offense date in this case is March 28th of 2019. The defendant was booked in the Bexar County Jail and released from jail on March 29th of 2019. Your Honor, this is a blood test case. The labs were issued to the state on April 29th of 2019. The state formally filed the information and complaint on May 7th of 2019. Your Honor, the defendant was issued a failure to appear warrant on January 30th of 2020. Your Honor, furthermore, there was a hearing on January 24th, 2020 to amend the information. Additionally, the forensic scientist that initially tested the blood has become unavailable, and the state did have the blood retested, which was received by the state on March 13th of 2020. Your Honor, the reasons for delay in this case, other than the things that I just mentioned, as you stated, the pandemic, Your Honor, the state's position is that the defendant has not proved sufficient prejudice because he had minimal pretrial incarceration. He did not lose his job as a result of these charges, and he has been able to obtain employment during this time, Your Honor.
In cause number 611348, State of Texas versus Scott Mormon, and defense motion to set aside information for failure to afford constitutional right to speedy trial is granted. Anything further from the state of the defense on Mr. Mormon?
No, sir.
Good luck, Mr. Mormon. Thank you for your service. And he probably can't hear that, so please relay that to him.
Yes, sir.
Thank you, Ernie. You're dismissed.
Thank you, Judge.
Okay, I know we're running late. Sorry, Mr. Zimmerman. Let's see what we got on you. Let's take about a 2-minute break so I can get refill my glass of water. Mr. Mormon, can you hear me, sir? We lost him again?
Yeah, he's locked up. I'll call him, Judge.
All right. Thank you, Ernie.
Thank you, sir.
Give me about 2 minutes to go get a glass of water and I'll be right back, Mr. Zimmerman. We'll take up your case.
No problem at all, Judge.
Mr. Mormon, the judge has already ruled. Your attorney is going to be calling you.
Oh, okay. I just keep fading in and out.
Okay, but he's going to call you. The judge has ruled and your attorney's supposed to be calling you.
Oh.
So you can leave now.
Oh, okay. Okay.
Okay, back on record. Have we got the state still with us? There we go.
Yes, Your Honor.
This is cause number 568-917 to the Texas versus Lydia Irene Martinez. The defendant's motion to dismiss for failure to provide speedy trial. Ms. Martinez is represented by Mr. Zimmerman, and Ms. Martinez is not required to be present. Is she present?
She is not, Judge.
Okay, that's fine. What I would like to get from both parties before we get into this is the specific critical dates, the date of the arrest. Do we have that, someone?
Yes, Judge, I have that, which is included in the defendant's motion to dismiss for failure to provide speedy trial. The state alleges that the offense of prostitution occurred on or about January 27th, 2018.
Okay. And then what date was the information filed? Do we know that?
Yes, Judge, and that's also included in the motion to dismiss on or about March 22nd. At least that's what the information, the copy of the information that I received.
Of 2018, is that correct?
What's that?
Of 2018?
Yes, yes, March 22nd, 2018. Yes.
It was apparently filed at large. Is that correct? Because
Yes.
she wasn't actually arrested and booked until August 7th, 2020?
Correct, Judge.
Okay.
Yes, Judge, and we'll stipulate to that.
Okay. And okay. And so, Mr. Zimmerman, a big part of this is going to be prong for the prejudice suffered by the defendant, because I think all the other time angles are probably pretty much met, other than the state might have a response on any speed bumps in the road with regard to the actual length of time. And I don't know if she was rearrested or in jail part of this time, so you're going to tell me all that. So go ahead.
Yes, Judge. I guess we're going to go into prejudice, which is basically argument. Judge, she has related to me over the telephone that she has had difficulty in obtaining witnesses.
Your Honor,
who-
I'm going to object to hearsay. The defense is not here to testify regarding the actual prejudice.
Okay, well, for purposes of the hearing, I won't overrule that in the nicest possible way. Go ahead, Mr. Zimmerman.
Okay, Judge, thank
We
you.
had a jury, we'd talk again, but we don't have a jury. Go ahead.
Yes, Judge, she has related to me that witnesses that not so much for the guilt innocent phase, but for the sentencing phase, if it came to that, witnesses who were familiar with her at that time have since she's lost track of. So she does not have those witnesses available. In addition, Judge, she has suffered anxiety, nervousness concerning this charge, manifested by sleeplessness and upset stomach, that type of thing, Judge.
Tell me this, what specific witnesses has the defense lost as a result of the delay in time?
She has not given me the specific names, Judge. I related to her that that would be necessary for the court, but she has not given me those names yet.
Okay.
But at that time, Judge, she is indigent, and at that time, witnesses tend to be somewhat transitory.
All right, let me ask you this. Apparently she's charged with prostitution. I'm assuming that normally these cases, there's one officer that acts undercover in some capacity and is allegedly solicited by the defendant. Is that what happened in this case from the defense understanding?
My understanding, that is what happened in this case, Judge.
All right, so what other witnesses would there be other than the police officer and the defendant?
Exactly, Judge. That's why I said that related to the court, that the witnesses would be more in the sentencing phase as opposed to guilt innocence.
And while I got you, Mr. Zimmerman, can you tell me what amount of time Ms. Martinez spent in jail as a result of these charges?
She just spent a day, Judge. She was arrested on this on August the 7th of 2020. And she was released on August the 8th, as best as I can determine.
And have there been any violation reports or other pretrial problems, or everything's gone okay other than that you're aware of?
That I'm aware of, no other problems, Judge.
Okay. Do you have anything else you'd like to add at this point before I go to the state on some of this?
Yeah, just for redirect, I will hopeful for re-argument, Judge.
All right, that's fair enough. State, go ahead.
Thank you, Your Honor. So, Judge, based on the Barker factors, I'm not going to argue about the first one. This is a 2018 case, so I'll just move on, Your Honor.
All right.
Let's talk about the second factor, Judge, which is the reason for the delay. Basically, Judge, we're trying to determine who's more at fault, the state or the defendant. And that's under Hopper versus State. That's a CCA case from 2017. Basically, Judge, I'm going to ask for judicial notice that the jury trials have been suspended for quite a while. For some time this year and last year due to COVID-19, which we all know it's a pandemic. I believe, Judge, that should not weigh against the state. Also, Your Honor, this case was, as far as I know, this case was set for a jury trial until August 23rd, 2021. That has nothing to do with the state's decision or ready or not ready. It's just that a 2018 case was set for trial until August 2021. As far as I know, Your Honor, the state hasn't announced not ready. So I believe that should not weigh against the state. Now, moving on to the third prong, which is the defendant's assertion of, in this case, her speedy trial right. The defendant, as far as I know, Your Honor, she asserted her right until June 2021. The defendant's asking for a dismissal. They're not asking for a speedy trial. So I believe that that's a consideration that should weigh against the defense. Now, the last prong, Your Honor, the prejudice to the defendant. First of all, the defendant is not even showing up to show prejudice. We're just hearing hearsay statements from the defendant. Also, Your Honor, the nature of the offense is prostitution. We discussed that a little bit. As far as I know, this is a typical prostitution case. I'm not going to get into the details of the facts. So I don't know what witnesses the defense might, I guess, offer, their testimony during trial. As far as I know, it's just the police and the defendant. And if anything, Your Honor, the more time that passes, that affects the state's case, not the defendant's case. So that should weigh against the defendant. Also, Judge, I don't believe that the defense established prejudice. Like Mr. Zimmerman stated, she only spent 1 day in jail. And if I may, yes, this case was filed at large. I don't believe that the defendant was arrested at the scene. According to my notes, and I'm going to ask the court to for judicial notice of the D page or the events page in the system. And based on that, Your Honor, the warrant was executed until August 7, 2020. And yes, the defendant was released on August 8 of 2020. So she spent 1 day in jail. Also, it's fair to say that the defendant didn't suffer any prejudice before the warrant was executed. Why? Because she probably didn't even know that this case was pending because she was not arrested at the scene. And for that, Judge, we ask the court to deny the defense motion for speedy trial.
All right, just you brought up, you want the court to take judicial notice of the Supreme Court orders under COVID restricting jury trials, and also the standard operating procedures of County Court Law number 6, which have restricted jury trials. And I have done that. We have not had a jury trial. I'll just start March 2020 to the present based on Supreme Court orders and my policy. So I'm taking judicial notice of that. And Mr. Zimmerman, I'll be happy to hear your argument. Are you in contact with Ms. Martinez at this time? We're not having any problem there?
Yes, Judge, I was in contact with her a couple of months ago, did notify her of the trial date of November 3rd, I believe it is. And I have not had contact with her since then, Judge.
I assume she's out on bond and we haven't had any problems. I'm looking at her D page. It doesn't really show any problems.
Yeah, I don't think there's been any problems, Judge.
Okay.
Judge, if I
Go
may
ahead,
address some of the arguments made by the state.
Sure.
The speedy trial, this case was asserted by speedy trial on a motion for speedy trial prior to the motion for dismissal, Judge. And so that she has asserted her right to speedy trial. So this is not just a motion to dismiss, it is a motion for speedy trial, in addition to a motion to dismiss for lack of a speedy trial, Judge. And under Cantu v. State at 253 Southwest 3rd, 273, the accused burden of proof varies inversely with the state's degree of culpability for the delay. In other words, the greater the length of delay, the more culpable the state is for that delay, Judge. In addition, this COVID was, or the disruption of COVID occurred in March of 2020. This case, the offense date is January 27th, 2018, and the information was filed on this case in March of 2018. So it was 2 full years prior to COVID. So trying to use COVID as a prophylactic on this case is inapplicable. They had plenty of time prior to COVID to pursue action against Ms. Martinez, and the state failed to do so. They were negligent in that area, Judge. As far as the assertion, we did assert that this was, I believe, in June of this year for a speedy trial, and then in August for a dismissal, Judge. But again, as I said, that is inversely related to the length of the delay by the state. And so we would request from the court that this case be dismissed for failure to provide speedy trial.
Cause number 568-917, State of Texas versus Lydia Irene Martinez, defendant's motion to dismiss for failure to provide speedy trial is respectfully denied. Is this lady eligible for pretrial diversion, State?
Check, Your Honor.
Is that something y'all might consider, Mr. Zimmerman?
Yes, I have not really received much of a negotiation with the state. They did make an offer on March 22nd of this year, but pretrial diversion is always something that should be considered as part of her decision-making process.
Your Honor, I'm not aware of the offer made by the state. I believe that was done by a private prosecutor. However, what I can say is I do see some criminal history in this regarding the defendant, but given the nature of the offense, PTD would be something that we could consider.
How about if this gives you enough time in the next 10 days, take a look at this case and then advise Mr. Zimmerman what options are available, whether she's eligible for pretrial diversion and they could apply, or, what your big deal of the day is, that kind of thing. Is that okay with you, Mr. Zimmerman?
That's fine with me, Your Honor.
Is that okay with you, Mr. Zimmerman?
Yeah, that's fine, Judge, with defense.
And what is this? Is this lady currently set for trial? What is she set for at this point?
Yeah, I believe she's set for November.
November the 2nd.
Okay. That's
Yeah.
all I got. Anybody got anything else?
That's all we
Okay.
have, Judge.
Thank you, Mr. Zimmerman. You're cut loose.
Thank you, Judge.
And now we got Mr. Brendel. Mr. Brendel, you've been very patient. You still with us?
Yes, Your Honor, I'm here.
Okay, sorry for the delays, because one of those days. All right, this is cause 619339. State of Texas versus Tyler Howard, and you know I haven't been doing this properly. I've got a document that is titled Defendant's Consent to Hearing by Video Conference, which reports to have both Mr. Howard's and Mr. Brendel's signature. In fact, Mr. Howard, is this your signature on this document? And your microphone.
Yes, sir.
Thank you.
Yes, Your Honor.
And Mr. Brendel, as attorney for Mr. Howard, is this your signature on this document also?
Yes, Your Honor.
Thank you. Now I've got a motion for speedy trial to dismiss for denial of speedy trial. And let's establish dates if we could. Let me see what I got on that. The arrest date would be 7/18/2019. Does that sound right?
Yes, Your Honor. Actually, the offense report I have, on the date, it was scribbled and it looked like an 8, but it's actually 18 according to the Bexar County system.
Okay. Okay. And the information was filed on what date? Can we determine that?
Checking right now, Your Honor.
We had the file, we just opened it and there it is.
The complaint was filed on July 18, 2019.
Yeah, but the information won't be filed on the same day, I don't think.
Judge, I'll ask for judicial notice of what they call the D page or the events page. According to that information, Your Honor, the file was sent to the court on November 9th, 2020.
That still doesn't tell us when the information was filed, correct?
On that same date, the complaint was received by central filing.
On
That would be-
11/9/20?
Yes,
All right, so that 11/9/20 is the date we're assuming an information was filed on this case.
that's my understanding, Judge.
All right. And the date this motion was filed is 7/23/21. We agree on that?
Yes, Your Honor.
Okay, those are my 3 critical dates. Go ahead, Mr. Brendel, and tell me what it is you're requesting based on the 4 prongs for the test under Wingo on.
As stated in my actual motion I submitted with the court, we'll take judicial notice of that. Defendant was arrested actually on July 18th for driving while intoxicated. He bonded out of the Bexar County Jail on July 24th, 2019. The state of Texas misplaced the defendant's file containing defendant's blood results dated October 3rd, 2019, which resulted in a delay in the prosecution of the case for about 2 years from the day of this filing of this motion, which was back in July, which defendant and the defense had to accept, since the defendant was under the impression that the blood results were still being processed by the Department of Public Safety. We did not get notice of the blood results coming in until actually February of this year, 2021. The case was reset to March, and we actually found out shortly before that. As a result of this delay, defendant has suffered a long burden of strict pretrial conditions. He's used a portable breathalyzer all the way back to 2019, 2020,
Judge,
several times
Again,
a day.
just for the record, I'm going to object on hearsay and lack of personal knowledge.
Okay, overruled for purposes of this hearing. Go ahead, Mr. Brendel.
Thank you. And despite the blood results coming in, actually, his blood results were under the legal limit of 0.08. And they were actually, let's see, I believe it was 0.56 0.056 according to the lab test from the DPS. There's a subsequent lab test ordered after those came in for a drug test, but the actual blood alcohol level was below the legal limit. So he had the portable breathalyzer a long time prior to that, although his legal limit was clearly below. His limit was clearly below the legal limit of 0.08. Defendant has been restrained of his liberty and suffered prejudice by having to, abide by his stringent bond conditions. It's limited his ability to travel, and actually, he hasn't had a driver's license since then because it's in Illinois and it's been on hold because of this pending charge. So he's had the limited ability to travel, attend college. He's had to do his classes online most of the time. He does make straight A's. I've seen his transcript. He's a very good student, and this is really, holding his ability to get his education. He's majoring in business, and he even he's made straight A's on some of the transcripts I saw. He's attending college has been restricted. He hasn't been able to socialize very much. Obviously, he hasn't been able to drive. And that has caused him mental anguish. Obviously, he's in his mid-20s and, he wants to do everything that his friends are doing. But when he can't drive, he can't, go out and do stuff. The defendant asserted his right to a speedy trial by inquiring as to the blood test results all the way back when the date was reported, and all the way before that. We always asked at the hearing to blood testers ready, and we didn't know that until February of 2021. And in order for the case to go to trial, obviously the blood tests have to be in, and because those we weren't able to have a trial on that. Also, we have never filed a motion for continuance and remained ready for trial in this case. The state must, there's under either Texas or federal constitutional claims, 4 factors are weighed. Obviously, length of delay, the reason for delay, the defendant's assertion of right, and prejudice. The state must satisfy its burden of justifying the length of the delay here. And defendant must prove asserted his right to speedy trial and showing a prejudice. We did this by this motion, honestly, by asking for the blood tests. The defendant has been unable to secure the trial date in this case due to the delays purely failing on the state of Texas. And as we talked about before, he's been severely prejudiced due to his restrictions on his ability to travel, attend college, socialize, and having to comply with and maintain his bond. And as you see on the prayer at the end of this motion, and at the beginning, we do ask this honorable court grant defendant's motion for the speedy trial, or an alternative, dismiss this information against defendant for denial of his constitutional right to speedy trial. The blood results that we received late, although they had been with the prosecution, clearly indicated his blood alcohol was under the legal limit of 0.08. It's a very defensible case in this aspect. So we do pray that the court dismisses this case, especially for all the prejudice that the defendant has had to go under, with the breathalyzer for several years, and, not being able to drive at all, and, having been restricted to college and just doing online classes, and especially how smart he is. He could be a very, important person, and this is just really restrict his ability to do a lot of things. So that's what we're asking for.
All right, let me ask you a couple of questions and then I'm gonna let the state jump in. Arrest date, July 18th, 2019. From then until now, was there ever any time, but this case was not filed at large, was it? He was just arrested at the scene and put in jail for one day or several days, I guess. From the 18th to the 24th was his jail time. Does that sound right? But that was in 21. or in 19? I'm assuming 7/18 to 7/24, 2019, he was in jail. 18, 19, 20, 21, 22, 23, like 7 days at the time of the arrest. Does that sound right?
No, Judge. If I may,
Yeah, go ahead. I'm just trying
according
to
to
get the
the
dates and the facts.
yes, so according to the information, the defendant was arrested on July 18, 2019, and he was released on that same day. So he only has 1 day of jail time.
Okay. From July 18th, 2019, he's always been in County Court 6. We agree on that? Looks like he's had several lawyers over the course of this.
Yes, Judge, and that's part of the state's argument, but as far as I know, this case has always been in County Court 6.
Okay, and Ms. Benavides, I'm going to call you as a witness to clarify what's going on this record because I can't read it. Raise your right hand, please. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth to help you God?
I
Ms.
do.
Benavides, you are the court coordinator for County Court 6 and have been so for approximately 11 years. Is that accurate?
Yes, sir.
All right. Without being indicted, I might add.
Thank you.
Thank you. Can you kind of take us by the hand and lead us from the arrest date, July 18, 2019, to the present on what happened with regard to the processing of Mr. Howard?
Let me just go back into the system, Your Honor. And pull that up. Okay, you want to know since he was booked, Your Honor, is that correct?
7/18/19 should have been the date of booking, the day that he was arrested. And
Okay,
the
hold
actual
on, Your
arraignment
Honor.
date-
Hold a minute. What I have here, Your Honor, is I need to go back to the beginning and then I will tell you. Okay. All right. The first booking, oh, I'm sorry, Your Honor, I pulled up the wrong person and I apologize. I thought I had that one. Okay, bond was made 7/18/2019. He was released from jail on that day. He was, let's see. He hired an attorney initially on 7/26/2019. There was a substitution of counsel, 10/3/2019. And it looks like, Your Honor, that there might have been a violation report at one time.
There
And,
were 2 violation reports, but those don't
Right,
really have any
and so
direct
he,
bearing on what we're talking about.
you don't need to know those, okay, because he was booked off and on, Your Honor, during that time period. Okay.
I show an arraignment date of 8/13/2019.
We've got the complaint. The next thing that happens, Your Honor, was the complaint was filed and 11/9/2020. We received a file 11/12/2020. The first arraignment that I see, Your Honor, is February 10th, 2021.
So we're missing a lot of time in here. Was he at large at some point, Mr. Rendell, or where'd all this time go?
Well, I think what happened, Your Honor, is during the time with the violation reports, he may have had some time. where he was at large, and then it looks like the attorneys would approach you, Your Honor, and the warrants would be lifted.
Okay, so at what point was he actually set for a jury trial by you, I guess?
Okay, hold on, Your Honor. I'll give you. The first time, Your Honor, on March 9th, 2021, he was set for trial August 2nd, 2021, and the trials have been reset, Your Honor.
Okay, that's what I need to know. Any questions for Ms. Benavides? State?
I do, Your Honor, if I may.
Sure.
So, Ms. Benavides, is it fair to say that the defendant only spent 1 day in jail?
As according to the system, he only has 1 day credit, which means that, yes.
Okay, and as far as you know, and or according to the system, is it fair to say that the defendant substituted counsel or legal counsel several times?
Yes.
And according to your notes or the system or any information that you have access to, is it fair to say that the defendant hired a new attorney on February 4th, 2021?
Hold on. On February what?
4th. Of 2021?
Well, there was a substitution of counsel at that.
So when was the first time that the defendant
Hired
had
counsel.
a defense attorney? Yes.
Okay. The first time he got a defense attorney?
Yes, ma'am.
He was appointed by the system July 18th, 2019. He was appointed one by the system. on that
Okay,
date.
but that was not his only attorney, right? I mean,
No.
did that, who was the next attorney?
Let me see. The first attorney was hired July 26, 2019.
Okay, and did he hire another attorney after that?
I can't say whether he was, it was a different attorney that was hired. All I can say is the first substitution was October 3rd, 2019, and it was a substitution of counsel.
I'm sorry, you said October?
October 3rd, 2019. That was the first substitution of counsel.
Okay, and so, but you mentioned that he hired an attorney on February 4th, 2021, correct?
Hold on. On February 4th, a substitution of counsel.
Okay, and do you see another substitution of counsel after that date?
Hold on.
Approximately around May 17th, 2021?
Hold on. May 17, 2021, there was another motion for substitution of counsel. Grant.
Okay, and was that the last motion that you see for substitution of counsel, or do you see another one on July 19, 2021?
That was the day that the judge granted the motion to substitute counsel. So it was granting the original motion of 714.
Okay, so you would agree with me that these changes or modifications, those are coming from the defense, right?
Yes, sir.
not from the state?
No, sir. Not for-
Okay, and now you also testify that the defendant, or that according to the system, you see a violation report.
Yes, sir.
What is the date of the violation report?
Which one here?
Is there more than one?
I believe so. Hold on.
Let's talk about the first one. Do you have the date?
I'm going to object to this. This is kind of out of the scope of what we're doing here, discussing the violation reports. He's had the breathalyzer for a really long time, a couple of years, using it several times a day. Violation reports happen, but I don't see how that has to do anything with what we're doing here. And just to clarify, he hired our firm back on July 26th. So the motion for substitute of counsels, we're just within our firm, and we're all within walking distance over here in the hallways, and we all work together as a team. So I just wanted to clarify that.
May I respond, Your Honor?
Let me hang on just a second. Relevance, Mr. Flores. What relevance is there
Yes.
that there may have been one attorney or 100 attorneys and or there are two violation reports? So what relevance is that to what we're talking about today?
Yes, Your Honor. Let me go one by one. First, the fact that several attorneys were involved in this case, that delays the proceeding, and that's not the state's fault. And that goes to the length of the delay, Judge, and that's our relevance. The second one, I'm asking about the VR, the violation reports, because as far as I know, and you can correct me, Judge, every time there's a violation report, the court modifies the pretrial conditions, the bond conditions. So that goes to the prejudice that the defendant is alleging.
Okay, well, you made both those points, no problem. I don't really see where having one lawyer or 100 lawyers is causing any more delays. You know, I assume every new lawyer has to start over again, sort of on the case, which I guess is the point you're making. Is that kind of where you're coming from?
Yes, Judge. My point is that that is not the state's fault in regards to the discovery and things like that. May I continue, Judge?
Yes, you may. I'm sorry to interrupt. Go ahead.
Thank you, Your Honor. So, Ms. Benavides, did you find the date of the first violation report?
Hold on.
Can I object to that again as relevance of the?
Saying the objection, I don't want to talk about violation reports anymore. You've already made your point. Move along.
Thank you, Your Honor. And I pass a witness.
Ms. Benavides,
Yes, sir.
when you see the motion to substitute, this is the understanding that this was the same firm, and it was just basically the person's name on there. We do work together as a team, so this wasn't a motion to substitute for any other lawyers and any other firms or anything like that.
Mr. Brindell, I am looking at the system. I cannot distinguish whether it is a new hire or whether it is a member of the same firm. All I can state is that there was a motion to substitute entered.
All right, let me jump in. A, irrelevant. I don't want to talk about new lawyers or how many lawyers were involved in this. That's already, you made your point, state. B, violation reports. I don't want to talk about those. Those don't cause any more time. I want to talk about time. So, Mr. Flores, if you have any questions pertaining to the time frames of all this, not talking about violation reports or new lawyers coming on board, go ahead.
Yes, Judge. Only if I may, that was Mr. Brindell's question. But yes, Judge. I guess my only question is, and last question for Ms. Benavides. Ms. Benavides, are you aware that there's a global pandemic right now?
Yes, sir.
And as I know you're not an expert in health systems or treatments, but when, as far as you know, when did the jury trials get canceled as a result of the COVID-19 pandemic?
It would be the third Monday of March. That was our last, that we canceled those of 2020, March 2020 was our last trials.
And that's because of COVID, right?
Yes, we were shut down on March 16th, 2020.
So that's not because of a request made by the prosecution, is that correct?
That's, as far as I know, we were shut down.
Okay. Pass it with
That was done by request made by God, who started the COVID thing. Go ahead.
I just want to add that our motion, nowhere in our motion do we really say anything about COVID. This motion is based on the fact that the blood tests were ready long before we were actually, after we asked several times, we were informed early 2021 that they actually were ready, but they just didn't see them. And the COVID situation happened around what we said, earlier, that it was earlier in that year. But this was, a year or so where we could have set it for trial had we had the blood test, but we could not. So, the COVID situation just compounded it. But really, I mean, most of the delay was caused by the fact that the blood test results were in. But when we asked for them, we were told that they were not.
What date would that be, Mr. Brendel, when the blood tests were in that you were not so advised they were in?
The blood tests were submitted and dated October 3rd, 2019. We had asked for the blood retest all the way up till February of 2021, where the case was reset pending those blood tests. And then we were informed right after that they had come in prior to that. So there was a year there where they were just misplaced, and we were unable to do anything with the case pending having those results. So the delay was, that was the reason for the delay. We filed this motion here in July, this year. It's now October. And of course, the motion wasn't heard because of the suspension of the jury trials. But I will reiterate that, the main reason for the delay was that the blood results were in, but they were misplaced.
All right,
Judge, I have-
Everybody stop talking, please. All right. Correct me if I'm wrong. State, this is a question for you. Arrest date, July 18th, 2019. Apparently there was a blood test taken. What date did the state receive the blood test back from the lab?
Yes, Your Honor, thank you. And I do have a response to Mr. Brendel's, and this is regarding the labs. Mr. Brendel's alleging in his motion that the state misplaced the defendant's file containing the defendant's blood results. So, Judge, just to clarify, this case, and I'm saying this because they opened the door, this case is a drug DWI, and it's standard procedure that if the BAC is below 0.08, the state always tests the blood again for drugs, which is a drug toxicology report. As far as I know, Your Honor, this case was a red file for a while. The state uploaded and this is in the e-discovery portal, the alcohol toxicology report on October 4th.
You're breaking up. Did you say
Mr. Brendel
October?
just stated that 4th, 2019, that's the alcohol toxicology report. Now, the defense is saying that they received the drug toxicology report until February of 2021. Judge, I can share my screen to show the system that it shows us when the labs were uploaded. And according to my system, Judge, the drug toxicology report was uploaded and disclosed to the defense on July 15, 2020. That's a long time until February 2021. And I can share the screen and I can show that to the court if you want me to, Judge. But that's the date that I have. And that's only in regards to the length. I'm sorry, to the reason for the delay.
Okay, let me back up because you got me confused. The arrest date was 7/18/2019. That's when they would have taken a blood specimen.
Yes,
You sent the blood off to the DPS lab, I'm guessing. You got the DA's office got the blood report back from DPS lab on October 4th, 2019. Does that sound right?
that's when, as far as I know, Judge, that's when the lab was uploaded into the e-discovery portal.
All right. So was it available to the defense on October the 4th, 2019 or shortly thereafter?
That's my understanding, Judge.
All right, Mr. Brendel, do you agree with that?
No, that's not correct. And just to add, although he says that the drug report was dated June 26, 2020, the BAC report is really important in the case, and the case cannot proceed to trial without the blood alcohol report. And we did not receive notice that the labs were ready until early this year. As far as the blood alcohol was concerned, our case was reset pending those blood results early this year. So, that's not necessary. That's not true. But you have to have the BAC report and the drug report to proceed with trial. You just can't, have a portion of it. And like you said, the blood alcohol report was dated in October and issued October 3rd, 2019. So it was there, and we just didn't receive notice of it. And we had asked for resets, saying that it was not available all the way to early 2021.
All right, Mr. Brendel, when did you become the primary attorney on this case?
I became the primary attorney in July of this year, right when you can see as the motion was filed, it was under my name.
And so when was the defense discovery motion filed, by you or by a previous attorney?
It was filed by a previous attorney with our firm.
Okay. And so what date did you, maybe you haven't received yet, what date did you actually receive the blood report from the state website, or I assume the DA's website?
We received notice that the blood results were in February 9, 2021. We had previously reset the case to March 2nd of earlier this year because we were told that the blood tests were not ready for the blood alcohol level. And then when we were informed that they were ready shortly after that, it was under the blood alcohol content of 0.05. So we didn't even, receive that until earlier this year. The case was reset because we were asking to see if they were ready, and then we were told they were not. Okay. All the way up until then.
So state, was the blood result 0.05, or what was the DPS lab blood?
Okay,
result?
Your Honor, I have several answers. One, I disagree that we need the BAC lab.
Just answer my question. I understand that both you guys disagree. I got it.
Okay, Judge.
What was the result of the blood test that you received on 10/4/19 as a DA?
Just for clarification, Judge, so there are two labs. One is the one with the alcohol BAC, and the second one is the drug lab, the drug toxicology report. So the system shows, and Your Honor, would you like me to share screen so I can show you the dates in the system? They show when the file was
there, because I don't know anything about this case. Apparently, the defendant, they took a blood sample from the defendant at the time of the arrest. The blood sample came back October 4th, 2019. It was below 0.08. So at that time, the state sent the the blood sample off to get tested for drugs to make it a drug DWI. Does that sound right?
Yes, Your Honor.
All right, Mr. Brendel, do you agree that that's what happened?
That's maybe what they did, but we were told that the blood tests are not ready all the way up to the earlier this year. So
I didn't understand about the lower than 0.08 thing. All right, I got it. State, do you have anything else you want to talk about before I let you argue?
Well, that's just just in regards to the lapse, Judge, like I said, I can show the system that shows all the
No,
dates.
that makes perfect sense. I just didn't understand it before you clarified.
And I also have an argument in regards to the other factors under Barker, Judge, but I can wait until you let me.
I got the time stuff figured out. What I want to hear about is prejudice. So state, tell me what your side evaluation is on prejudice to the defendant.
Yes, Your Honor. One moment, please. Okay, Judge. So in this case, Judge, it's the state's position that the defendant has failed to assert or to prove prejudice in this case. Basically, Your Honor, the defendant, all we heard were hearsay statements, and so that's all we have. Now, there's case law that says that the defense is required to show any anxiety or concern beyond the level normally associated with being charged. And that's under Shaw, which is a court criminal appeals case. Now, in this case, Your Honor, there's testimony that establishes that the defendant was, there's several violation reports. And so that goes to the modification of the bond.
I'm going to
condition.
object to that. That was objected prior to.
Judge, they opened the door by saying
All right,
that.
everybody stop talking for a minute. State, what were you talking about that the defense objected to?
The violation report, Judge, that goes to the conditions
I'm
of.
going to sustain the objection. I don't care about violation reports. Keep going about prejudice. That has nothing to do with prejudice. Go ahead.
Okay, Your Honor. So basically, we believe that the defendant failed to establish prejudice. Again, Judge, all we heard were hearsay statements, and they mentioned the fact that he can't socialize, and they also mentioned mental anguish, but that's, the state's position is that that's not beyond the legal standard, which is any anxiety or concern beyond the level normally associated with being charged. In this case, the nature of the offense is DWI, and so the bond conditions obviously are related to the intoxication charge.
Okay, Mr. Brendel, I'm keenly interested in the defense side of prejudice to the defendant, and you hit it pretty hard earlier on, but you're welcome to add to that if you wish.
Yeah, as I mentioned before, because of this pending charge, defendant has not been able to get a driver's license because it's in Illinois, and the pending charge makes it to where he wasn't able to get one here. He has not been able to drive a car. He has not been able to travel, which interstate is actually a constitutional right that was infringed on by that. Not only that, obviously he's in his mid-20s. Because he can't drive, he's not able to travel to school. He's had to do most of his classes online. He hasn't been able to socialize like a normal person his age would be. And this thing has been going on since July of 2019. It is now October 5th, 2021. This is one of the longest cases I've ever seen as far as duration. And as I stated earlier, I mean, not being informed of the blood alcohol test results was the reason, that this delay was, and the COVID situation just compounded it for several months. But the defendant has suffered, obviously, just by what I stated, much more prejudice than any normal person would under these circumstances, especially since he used a breathalyzer. He's been using it for years, and having to do that several times a day, and also, drug tests and all that for, several years. This is beyond what any normal defendant would go through in this situation.
Okay. Clause number 619339, State of Texas versus Tyler Howard. The defense motion for speedy trial is granted. The defense motion to dismiss for denial of speedy trial is denied, both in the nicest possible way. That being said, state by this coming Wednesday, which would be the 20th I need to know from you, and Mr. Brendel would need to know from you if you're ready for trial on this case. You may know right now, for all I know.
We need some time to review.
Let's say for
Judge.
the sake of conversation, we want to go jury trial next week. Is the state ready?
Sorry, Judge, you're breaking up.
Yes, sir. Mr. Brendel and I need to know if the state is ready for a jury trial. Say in 10 days, would you be ready for a jury trial in this case?
Yes, Your Honor, under that time standard, yes.
All right. Well, confirm that and just get back to me and Mr. Brendel, my next Wednesday at 12 noon. And just confirm that you guys are ready to go. And if there's some sort of wonderful deal you're willing to offer Mr. Howard, you can discuss that with him too at that time. Will that be okay?
Will do, Your Honor.
All right. In the meantime, Pat, Mr. Howard is set for when?
January 10th.
Okay. Mr. Brendel, if that gets moved up, you'll be the first to know. You're our number 2 trial. The only reason you're number 2 and not number 1 is because we had a hearing an hour before this hearing that they snuck in front of you. Anything further from the state of the defense on Mr. Howard?
No, Your Honor.
All right,
No,
good
Your
luck, Mr. Howard. Thank you, Mr. Brendel.
Thank you.
Thank you, Your Honor.